This is case number 252875FY, appearances counsel.
Nick Carnes on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Rankin, who's joined me at the table.
And we are set for a probable cause conference. Is there any resolution in this matter?
There is not.
Looks like we are then moving forward to preliminary examination next week. Is there any discovery issues or any witness issues we need to be concerned with?
There is an outstanding SANE report that the prosecution has assured me is forthcoming, so I don't anticipate there being any issue.
Mr. Carnes, are you aware of anything else?
No, I'll just say it looks like that requires a protective order. I don't see one in the file. We'll draft that today and should be able to do this.
Do you have the same report?
I do have the same report. I don't see the protective order. I'll talk to our staff and get that done.
All right, we will keep this set for preliminary examination next week. Is there anything else we need to address?
Nothing.
No, you are.
All right, thank you. Our next call is people of the state of Michigan versus Todd Allen Burns. This is case number 25-3733FT, appearances counsel.
Nick Carnes on behalf of the people.
I'm Jeff Harrison. I represent Todd Burns.
Mr. Burns, I'm sorry, Mr. Harrison, why is your client still in custody?
Why is he
He's
still-
on Roscommon.
Oh, Roscommon?
Yeah.
All right.
Yeah, I'm sorry, I didn't hear your question.
All right. We are here for a probable cause conference. Is there any resolution in this matter?
Not at this time.
There is none.
All right, so we are set for a preliminary examination for next week. Is there any discovery issues or witness issues we need to address?
I don't believe so, Your Honor. I've been provided with the police report. I don't think there's any other outstanding supplement or anything that would be out there. I think the investigation is complete.
All right, Mr. Carnes, are you aware of anything?
No, you're on.
All right, so we will keep this set for a preliminary examination for next week. Anything else for the record?
Nothing.
No, you're on. Thank you.
Thank you.
Is your client under sentence in Roscommon or what's going on there, Mr. Harrison?
Okay, so they had a hold after I got my bond here, they had a hold from something previous. So I reported there too.
Okay, is that a new case?
No,
Is it a probation or?
no. It was a month before this one. Same person.
Okay, but have you been arraigned? You've not been arraigned on it?
No, I have a bond.
You do have a bond?
And I have reported there the 21st and here the 20th,
What is your bond?
7,500.
Okay. Well, the court is going to sua sponte, bring a bond motion because he's currently a personal recognizance bond. So I will set a $100 cash surety bond so that he does accrue jail credit while he's incarcerated.
Appreciate that, Your Honor.
I had 200 in my account here too. Going to housing now. I didn't get a check before I left.
Court next calls the case of people of the state of Michigan versus Stephanie Ferrante. 2631FY, appearances counsel.
Nick Carnes on behalf of the people.
Robert Hertel for Ms. Ferrante, who joins me at the table.
All right. We are here for a probable cause conference. It does not look like there's a resolution. Is that correct?
Correct, Your Honor. But there is a waiver of the 14-day rule. The people would ask for an adjournment in this to give more time to exchange discovery and hopefully come together at a resolution.
How is discovery coming together in this case? You still have you received anything yet?
There are drafts that I reviewed, but MSP needs to review those before I can hand them out. So I would say it could be a week before we're final.
So with the waiver of the 21 days, that puts us at the 27th. Do you think that's sufficient time?
27th
January.
January, I would ask that.
Would I oppose that, but if we could address bond going forward, I would appreciate it.
Mr. Hartel, any objection to addressing that? I'm sorry, Mr. Carnes.
No objection to defense raising the issue, Your Honor.
All right, so we will move this then to the 3rd of February, Mr. Hartel.
Yes, thank you, Your Honor. I did regroup with my client before coming in today. She does want me to address the bond situation. If the court was willing to consider lowering it, preferably to a personal recognizance. We do realize this is a serious case, serious allegations, but she's advised me that she does have family who is willing to put her up in a hotel room and pay for that, or an apartment maybe.
Yeah.
And that way she would have a firm residence. So if the court did still want to GPS tether her, she could do that. I just would hate to see her waiting in jail while this is continuing. And she does want to get all the discovery as well. For all we know, it might have exonerating stuff and it won't know until we see it. But at the same time, I would hate to see my client lodged pending that. Our office social worker, public defender's office, Mr. Brian Henniger, will gladly help her. Well, he can't in all the ways that he can, but her, I believe, mother, was it?
Yeah.
All right. Her mother is more than willing to help her initially get that. And if it is a GPS tether to an address, then obviously that would overcome some of the court's public safety concerns, hopefully. Thank you.
Mr. Carnes?
Thank you, Your Honor. I think bond is appropriate where it's currently set. These are serious allegations lying during a home invasion murder investigation. And the defendant has extensive criminal history from Kentucky and appears to have resided in Kentucky. So I think the seriousness of the offense and the defendant's lack of ties to this community are both concerning. I would ask court to keep bond where it's currently set. Thank you.
All right, when looking at the bond factors in 6.106, the court has considered the prior criminal record, so let's run through that. In 06, there was a robbery second, possession of forged instrument, theft, receipt of a stolen credit card or debit card, possession of burglary tools, theft, a receipt of a stolen credit or debit card. Then in another case, there was another robbery second, possession of cocaine, possession of burglar tools, theft, or receipt of a stolen credit or debit card, possession of a forged instrument second. In 6, there was a theft by unlawful taking, and in 17, a shoplifting under 500. Record of appearance or failed to appear. The praxis does not indicate that she has any failed to appears. A flight to avoid prosecution, there's nothing regarding that. History of substance abuse or addiction. The only thing the court has in that regard is back in 06, 20 years ago, possession of cocaine. Mental condition, character, reputation for dangerousness. The court has nothing regarding that other than the criminal history and the robbery second that goes along with that. The seriousness of the offense. She is charged as a habitual fourth offender, which makes it the 4-year felony up to a 15-year felony. Probability of conviction and likely sentence isn't going to be scored to her yet.
No, Your Honor, I have not.
No.
Employment, financial status, and history. I've not heard anything regarding that. Responsible members of the community who would vouch or monitor for her. Ties to the community, relationships, length of residence, and any other factors regarding risk, appearance, and danger to the public. I'll admit what the court knows on this case is limited exclusively to the affidavit of probable cause, which indicates that she was with somebody who is believed to have murdered somebody and then lied during the investigation. I also note, as Mr. Carnes did, that her criminal history is out of Kentucky. I don't know for certain what her ties to the community are. I do know at one point she was living in the homeless shelter, and then at another point had spent a couple days in a motel room. And then it does sound if she were to bond out, that she would then be placed in another hotel room possibly, which makes her very transient in nature, which does indicate that she is a potential flight risk. I also, based on what I know in the probable cause affidavit, or have read in the probable cause affidavit, I believe that she is also a threat to the community. Bond was set on this case back on January 5th with a $250,000 cash surety. I believe the bond is appropriately set, and I'm denying the request. Anything else for the record?
Thank you.
No, thank you.
I will say this, however, with discovery having not been provided yet, I realize we're not within the 21 days, but that would not stop me from reconsidering another motion in the future, pending what happens with discovery. Can we, yeah, I'm not gonna have, I didn't realize it was a plea to a felony. We're not gonna have time to do it. Oh, and it's a Killebrew 7411, so is that correct?
It is.
Yeah, so I'm not gonna take a sentence agreement plea.
Oh, so we just want to.
You would just waive and bind over to the circuit court.
That should be fine.
Okay.
Fine.
Are you okay if I go on after arraignments then and cannot be brought?
Yes.
Okay.
So more time to. find details.
Then we're done.
This way I would have. Oh, you were saying. Sometimes we can't.
Amy. We're gonna put Bowler on after arraignments just to read his
Okay.
amendment and then sign his waiver.
Yep, I got that. Okay.
I have to do something with tech support on my end, so it might be Mr. Harrison, but if it's just for an arraignment, that should be fine.
Yes.
You need to handle bullets around.
You may. Before I sign this, is there anything else we need to address on the record?
No, you're on.
No, Your Honor. I didn't realize you're still there, Jeff, sorry.
All right, I have signed the